start the recording. Okay. I told the students on Tuesday last week, I reminded them that tomorrow, Tuesday, is a public holiday, so that those of them can join us for the Monday if they are available to join us for Monday. Otherwise, we will do the recording and I will upload the recording. But again, thank you to the three of you for attending. And I thought, let us, it is quite important for us to start off with this section. We're looking at basically the second phase of your intro to commercial law. And this second phase is focused on the general principles of contract, right? So the general principles of contract, which means that we're going to look at what are the essential criteria for a contract. What are the essential criteria for a contract, etc. Right. Now, over the weekend, I think last week, Friday, I only managed to upload the slides, the updated slides for 2022. So I've updated the week 3 slides, and that is basically what we're going to talk about today. And basically looking at the definition, at formalities, and then at essential characteristics of a contract. Okay. I see Lurato is joining us as well. Good morning, Lurato. Okay, so let's talk about this. I've given you 3 sets of slides for this week, right? And you'll see it is quite easy slides and it is very short slides. And I was hoping if you have any questions on those slides that you would type it out maybe in the chat, or that you raise your hand if you want to ask me a question, and we can try to unpack whatever it is that are, let me just see here. Try to unpack if there's any issues specifically, right? But otherwise, and while we're waiting maybe, I'm going to say, let us look at those 3 slides and just highlight some of the main issues in the slides, right? So in the textbook, there is a very short segment in the textbook, and I'm going to share my screen. Okay. So remember, what we're doing now is we're looking at contracts, and we say in general, what are the essential criteria? What is the elements of a contract, right? So we first do this as a basic elements of contract, and then we go to specific contracts. So then we will go to the contract of sale, the contract of lease, credit agreements, etc. Right. So firstly, we're just looking generally. You will see there, I started off and I say, okay, here's all the textbook pages. Now, this is for the new textbook. Those of you who are working with the older textbook, right, you can have a look. The pages differ slightly. So let's say this one is page 41. In the old textbook, I think it would be page 43, right? So it's not completely new. You can easily find your way here. But these are the general principles of contract that we're going to look at. So we're not only going to look at what are the requirements for a contract, but if you look here at the bottom, we also include the breach and termination and remedies for breach, right? So we also include breach, termination, and the remedies. So that means if you've entered into the contract and the contract is valid and you have performed, but the other party has not performed, what can you do? How can you enforce that? And remember what we said with the courts, the judicial authority of the state. The courts are there to resolve issues, not for you to be a vigilante or for you to take matters into your own hands and beat up the guy until he agrees to pay you, right? So there's a court system that you have to follow in order to enforce a contract, right? Something now that I'm just thinking, just out of interest. In the past, if a person owed you money and they didn't pay you that money, and you went to court and you got a court order saying that they have to pay, right? It was possible to imprison a person, to threaten him with imprisonment if he doesn't pay. That is no longer the case, right? So for the past 20 years or 30 years nearly, no longer the case. You cannot send someone to jail if they have not paid. But what are your options? If you've sued someone and they are unable to pay you in terms of the contract, right? You have other remedies. So you can, for example, if you sold them your car, you can request that car to be returned plus damages to be paid. If the person cannot pay the damages, then of course you have the sheriff of the high court or the sheriff of the court that will go to that person's home or workplace and will attach items to the value of whatever the judgment is, right? So please keep that in mind. That is what when we say there's a breach of a contract, you sue the person in terms of that contract, or your remedies. You can either ask for that contract to be cancelled and damages, or you can ask for the contract to be enforced plus damages, right? So depending on that. But what are we going to look at? We're going to look at basically those first two aspects. So firstly, the definitions, and you'll see the slides. It is so short, 10 pages. It's nothing. But so firstly, with definition, right? I'm not going to ask you define a contract, but you need to know what is a contract, right? So you need to, and I think you already know this, you know that contracts are a daily occurrence. Contract is something that happens on a day-to-day basis. We use it everywhere we go. If we buy airtime from Cell C, if we pay for Checkers 6060 on your with your credit card or with your bank card, you know, online kind of transactions. So contracts, we say, the law respects the rights of people to enter into contracts and will enforce the contracts provided that the contracts are valid, so that it meets all the requirements, that the contracts are not illegal, right? So it must be lawful contracts. It must not be immoral, right? So you cannot agree in writing that what is that? You won't even know. It was an old movie, Indecent Proposal, right? You cannot agree that your wife sleeps with someone else and that they pay off your debt in return. You know, that kind of immoral contracts not allowed. And contracts must also, provided that it's not impossible to perform, right? So I cannot enter into a contract with you saying that I will sell you the sun, right? That is just an impossibility. I will never be able to do that, etc. Okay, but that just as a basis, if you say contracts, the law allows you to enter into various contracts, as long as it's not unlawful, as long as it's not immoral, as long as it is possible to perform in terms of that contract, right? Now, this, I think, important for you to know. If I say for 4 marks, what are the basic features of a contract? So basic features, that differs from essential elements, right? The essential elements are smaller bits in there. But what are the basic features of a contract? Right, okay. So I said there, the basic features are, firstly, an agreement. What does that mean, an agreement? It means there must be a meeting of minds, right? if I want to enter into a contract of sale with you, I must know that I am doing this. I must make an offer. You're going to make you're going to accept that offer, right? Or vice versa. So firstly, there must be an agreement. Secondly, it involves legal obligations. Now think back when we talked about this last week, legal obligation or legal liability. What does that mean? Obligation means that there is how would I put it? One person makes a promise to do something in exchange for something else. The obligation, that promise, that agreement can be enforced by the courts. So you can go to the court and say, here we have an agreement. It created a legal obligation that is enforceable by the courts. So it involves legal obligations. I said the obligations are between at least 2 or more parties. So usually, and this is where we come in with unilateral contract, a bilateral contract, and even the textbook refers to multilateral agreements, right? But what we say is a contract, an agreement is must be at least 2 or more parties, right? You cannot enter into a contract with yourself. And then lastly, the issue of privy, right? We say only the persons, oh, that is wrong. I have to fix that. Only the persons privy to the contract are bound to it. So that means only the people who know about the contract, who are involved in the contract, whose names are listed in the contract, those are bound to the contract, right? Why? Because a contract that you enter into is what we say a personal right. Remember, we said, what is the difference between a real right and a personal right? We said a personal right is a right that you have against a specific person. It can be enforced only against that specific person, right? Because it's a personal right. And then we say, so only the people who know about this contract, who is involved with this contract, can be bound to that contract, right? All right, please, hello to, good morning to those who have joined us now. Just want to see here on the chat. Yes, okay. All right, so the definition of a contract, that is basically, if we say, well, the basic features of a contract, right? This issue of a juristic act. A juristic act means action by people that are recognized by law and can be enforced by the law. So I said you get different kinds of juristic act. A unilateral juristic act, right? Unilateral means one person. So action by one person that creates some kind of contract or so. And that is, for example, where a person updates their will and testament, right? So when they die, that certain things go to certain people, etc. So a unilateral juristic act. And also we say, for example, where only one person has an obligation, for example, a donation. So when someone donates to the SPCA doesn't have to be a party to this contract and agree to the contract. This person decides he's going to donate. So it's a unilateral contract. Our contracts that we're going to work with is bilateral juristic acts. So that means 2 or more people involved in this agreement, right? And I mentioned there, sometimes it could even be multilateral. So bilateral means 2 people, right? Multilateral means more than 2 people. So that could be maybe if 3 people agree to this contract, right? Depending on what kind of contract it is, etc. Any questions so far on that, right? So with a contract, you need to know, so what is a contract, right? It is a juristic act, usually a bilateral juristic act. It has an agreement between two or more people, that there is legal obligations are created. The people who are involved with the contract are bound to that contract. It can be enforced, right? Okay, so there I mentioned again the legal obligation side, etc. And this, if you have a look at that last sentence there, I say one party, the creditor, has a right to receive performance of some kind from the other party who has a duty to render performance. Does that make sense, right? So let's say there's a contract of sale. I sell you my car for 50,000, right? When it comes to delivery of the vehicle, I have a duty to deliver the vehicle to you, and then you have a duty to receive that vehicle, right? Same with payment. You have the duty to pay the money over to me, and I have to accept that money or receive that money as part of the agreement. Else it won't be a contract of sale, right? Else it might be a donation or some other kind of contract. So the one party always has the right to performance, the right to receive performance, while the other party has the duty to render performance, the duty to give that performance. Right. All right, so just want to see, I mentioned there, if you talk about privy, right, the doctrine of privity, they call it, it means that only people who are involved with the contract should be bound to that contract. Right? So in general, I cannot enter into a contract on your behalf, right? Just because. I can only do that if I have your authority, your approval. If I'm acting as your agent, then only can I enter into a contract. Otherwise, only the people who are bound, who are involved with the contract, is bound to that. Right. Okay, so let us just read through this. These are the essential elements of a contract. And with these elements, we then look at each one of those elements saying, what does it mean? So firstly, element number one says there must be an agreement. What does it mean, agreement? We say consensus, that means a meeting of minds conveyed by an offer and acceptance. So we'll look at that next week. There must be an offer and there must be acceptance of that offer. Otherwise, there is no contract. Right. You will see, for example, if someone makes an offer and before the other people accept the offer, you are then entitled to withdraw the offer, right? So you have the person who makes the offer and the other person accepts the offer, then you have a meeting of minds. The second element says there must be an intention to create legally binding relationship. So that is referred to as animus contrahendi. Animus means the intention, the mind to enter into a contract, right? There must be intention. If a person is joking, if a person is not, is just saying, for example, if you tell your friend, okay, I promise we will meet up this weekend, right? That isn't a contract. Your friend cannot go to court and say, oh, you didn't meet up this weekend, so he's going to sue you now for damages. Right? There must be an intention to create a legal obligation. Number three, it says there must be a reality of consent between the parties. So that means the parties must do so voluntarily. There must be consent. If a person is forced to do something or forced, let's say, for example, if the person is under duress, yes, so that's the word. If you are forced, you are placed under duress, then that contract is voidable. You can go to the court and ask the court to set aside the contract. Okay. Okay, so number 4, we say essential elements. The parties must have capacity to enter into a contract. Capacity means you must be able to know that what you are doing is entering into a contract. You must be of a sufficient age. You must be of a sufficient mental capability to enter into a contract, right? So you cannot enter into a contract with a 3-year-old where you tell the 3-year-old just to make a mark, just to sign here on the list, because the 3-year-old does not have capacity to enter into a contract. So that's what we call capacity. Right? And we're going to look at the different age issues and mental health issues that affect capacity. Right. Number 5, we say the terms of the contract must be sufficiently certain to be enforced. So that is an essential element of a contract, that the term of the contract, if you look at the contract, you must know, okay, it's a contract of sale. There is a vehicle being sold. This is the vehicle. So you cannot just have, like say, one of my cattle will be sold. You have to identify the item a bit, right? You have to say, what is the purchase price? How will the purchase price be paid? Those kind of things. Right. Number 6, we say the contract must be possible of performance. So it must be possible for the parties to do that, what they have promised. I cannot promise you the sun and the moon and say, okay, well, now it's a contract, because it's not possible for me to provide you with the sun and the moon, right? Number 7, we say the contract must be lawful, right? So you cannot enter where you have an agreement with someone to assassinate someone else, right? That is not a contract that can be enforced in the court, right? You cannot go to court and say, well, I paid him the 10,000 Rand and he hasn't killed the person that I said he should kill, right? Ridiculous, but yes. Contracts must be lawful. And then lastly, any formalities required must be in place, right? So we're going to talk about the formalities then. Now talk about the formalities. I've included for you some videos that you can have a look at, short little clippets on a contract. So maybe you want to look at that. And yeah. And that is basically with definition, right? So just explain, what are the requirements? What are the essential elements of a contract? We're going to look at each one of those over the next 5 weeks, right? And then with the definition, explain what is a contract, that it is an agreement between parties that creates legal obligations that can be enforced by the state. The parties who enter into it are bound. We say the parties who are privy are bound to that agreement. And as I said, enforced by the state through the court system. Right. Okay, let's just pause there. Any questions there on the issue of the definitions? It is 14 pages, so that would take you, I don't know, even 5 minutes to read through, or 10 minutes to read through. I don't think there would be any specific or any catch out kind of questions or trick questions that I can have from that first set, but just so that you know, start off with the definition first, right? Okay. Now let's have a look at the second one. I'm also checking the chats just to see if there is any issues. Okay, doesn't seem so. So the next one on formalities, that you will see is a little bit longer, 23 pages, right? but it is not difficult concepts. So my question is, will formalities be required with all contracts? Think about that. Would the law, or would you require formalities with all your contracts that you enter into? Right? Or are there some contracts that have no formalities? Right? And think about that, because if people say a contract, I have a contract with you, they usually refer to a piece of paper that says this is a contract of sale, and I can show you on page 3 of the contract what is the purchase price, etc. So let's look at formalities, right? Formalities, we're going to say, do formalities apply? In some cases, you have statutory formalities, and in other cases, what we call self-imposed formalities. Right. So let's see. I said there, contracts in general, we would say, of all the contracts that you enter into on a daily basis, do not require formalities, right? So contracts in general do not require formalities. Certain types of contracts, there the state has said there must be formalities, right? For example, if you sell your house, they would say the contract of sale must be in writing, signed by both parties, endorsed by a notary, and registered with the deeds office. But if you go to a garage and you fill up your car, you are not entering, well, you are entering into a contract, but there is no written formality requirements. No? Imagine if you had to enter into a written contract every time. You go to Pick and Pay, now they give you a 12-page contract that you have to read through and sign before purchasing the goods. So what am I saying? Formalities in general are not required. Certain contracts require formalities. So we say, for a valid contract to be concluded between two or more parties, such parties must comply with requirements. Formality, if it is a requirement, applies to those circumstances where the agreement is required to be concluded in a specific manner. So we said there, in general, that no formalities are required. A valid contract can be entered into verbally. You do not even need in writing. Okay, let us see. If we talk about those formalities, I see there in the definition, we say formalities are those requirements relating to the outward visible form in which the agreement must be cast to create a valid contract. Like writing, signed by witnesses, dated, those kind of formalities may be required. So here, basically, you have two kinds of formalities: statutory formalities and then self-imposed formalities. Now, statutory formalities, I said there, some legislation requires contracts to be in a certain format. So it would say that the contract, for example, to transfer land, right? You have a farm, you want to subdivide the farm, you want to transfer a portion of the farm to someone else, that must be in writing and signed, okay? Some lease agreements, so lease agreements specifically where it's more than 3 years, those required must be in writing and signed. A suretyship contract. What is a suretyship? Suretyship is where you, say, apply to study at UKZN. You do not fall within the EFFYC bracket, right? So you have to pay for it yourself. Your parents do not have the money, but you go to a bank and you get a student loan, right? You would see that that student loan will be granted on provided that your parents sign as surety to your debt, right? So as surety, meaning the surety is the person who guarantees that the student will pay the debt, and so I sign off. If the student doesn't pay the debt, then they can come to me and claim the money from me. So a suretyship contract must be in writing. And then you also have other kinds of requirements. So we say there, very important, failure to comply with the formality requirements in a contract, where specifically where that is a statutory requirement, right, will generally result in the agreement being void, and any performance may then only be recovered under the doctrine of unjust enrichment. So if a contract is void because you did not meet the statutory formality requirements, any performance that was rendered in terms of that contract will be returned or sued for that performance based on that doctrine of unjustified enrichment. And remember, last week I mentioned unjustified enrichment was when one person is enriched whilst there was no legal basis for that person to do so. If I paid in, for example, 1,000 Rand into your bank account by mistake, I mixed up the two numbers or the account numbers, you are not entitled to that. You cannot say, oh, well, it's my lucky day, right? So the other party can then sue you based on unjustified enrichment. Now, I thought this was a very, very nice, I should have highlighted that in red as well. The Electronic Communication and Transaction Act says that for most contracts, or not most, let's say that says that contracts may be entered into through electronic means, right? So not that it has to be printed out on paper and signed in black ink by both parties, but by electronic means, meaning that you will be able to enter into a contract via email, via a telephone call, with an email, with a transcript where you have agreed to all the terms and conditions of Cell C, or where you have even WhatsApp. Yes. So you can even enter into a contract via WhatsApp. It is an electronic message, but it is accepted as a legitimate kind of contract or formality. Right. So statutory formalities, I mentioned here, and you will have to know this. So I would say discuss 3 of the types of statutory formalities, right? So discuss 3 of those for 6 marks, or 2 of those for 4 marks. So what are your statutory formalities? Firstly, legislation can require that a contract be a written record, that it must be reduced in writing in some or other way. Secondly, legislation can require that contract must be signed and initialed on each page. It can require notarial execution. Notarial means a notary public, that is a specialized attorney that drafts contracts, right? They are paid a lot to draft contracts, especially big international contracts, etc. And some of the legislation requires that the notary public drafts the contract and stamps or seals the contract, right? Registration, sometimes they require that the contract be registered somewhere. And then revenue stamps can also require revenue stamps. So revenue stamps are stamps that you purchase. I don't know where you purchase them. I think usually at the magistrate's office and at the, but a stamp that is then placed on the documents and that has for a formality for the statutory formalities. So I've set out for you each one of those. I've discussed under written record. I discussed signature, I discussed notarial execution, registration, and revenue stamps as well. Right. Okay. So have a look at that, read through those aspects. But now if I say discuss or give 2 examples of statutory formalities, right? The types of statutory formalities that you can say whatever you choose there, registration and what is meant by that, or in writing and what is meant by that. Okay. Any questions on this? Any questions on this? So we say formalities are not required as a general rule. It is not required as a general rule, right? Some legislation requires contracts to be in writing and signed, etc. Right? Or we say number 3, the third option there is self-imposed formalities. Now, self-imposed formalities means where there's no legislation requiring the formalities, but you, because you want to have certainty in the contract, you agree with the other party that this contract will be in writing, that this contract will only be valid from the date that it has been entered into, or that this contract will only be valid upon the date that the last signature is placed here on. Right. So self-imposed formalities, those look at the creation of the contract, the variation of the contract, I'll speak about that, amendments and cancellation of the contract. Right. So all of that can be regulated by some kind of formality. Now, I've set out for you the creation, variation, amendment, and cancellation. Right. But I want to specifically say there, some contracts, when we enter into a contract, there's a standard clause that says this contract is in writing and must be signed by both parties. Right? It says there any amendments or variation, that means changes to the contract, will only be allowed and will only be valid if the parties agree to that in writing. So there we have what we call a non-variation clause. So a non-variation clause, say they typically provides that no variation to the written contract is of any legal effect unless the variation is in writing and signed by both parties. Right. So unless it's in writing and signed by both parties, that is a self-imposed kind of formality. Right. So have a look at that. Self-imposed formalities can be with the creation of a contract, with variation or the amendment of a contract, and then also with cancellation of the contract. So let's say in my lease agreement, it says that I am not allowed to if I want to cancel the lease agreement, I have to do so in writing to the address of this landlord. Right. That would be a formality, a self-imposed formality regarding the cancellation of the agreement. Okay. Can I ask any questions on that, on the formalities? So what did we say? If there's a formality required and that formality has not been adhered to, that contract may be void. So what does that mean, a void contract? You can have void and voidable. A void contract is a contract that initially did not comply with the requirements, the general requirements of a contract in some or other way. And the law says that that contract was void from the beginning, which means that no contract came into play, right? So that is your one option. The other option that you would have is, you will see these, I've uploaded the table for you onto Learn, but voidable. A voidable contract is a contract that came into play, right? The contract is in effect, the contract is valid, but one party has the power, right, or the right, whatever you call it, the power to go to court and ask the court to declare the contract voidable for some or other reason. And usually a contract will be voidable where there was something wrong with the consent. So where a person was under duress, right? Where the person was under what we call undue influence, or where there was a misrepresentation being made. So void contract, that contract has never come into play. There's no contract. Any performance that you have made can be requested back in terms of unjust enrichment. There's no contract. A voidable agreement is an agreement that came into play where one of the parties go to court and ask the court to set aside that agreement based on some or other thing like misrepresentation or undue influence or duress, where someone forced him to sign that contract. Okay, and that, good people, you will find in the last slide for week 3, where we talk about essential elements, void and voidable. I've given you a table from the textbook. Those of you who haven't purchased the textbook as yet, so there is a small table that you can have a look at, the difference between void and voidable contracts, right? Now, when it comes to the essential elements, we've already listed those essential elements. It was about 8 essential elements, right? So we keep that in mind. Those are the essential elements. We're going to look at each one of those elements, right? But this slide does set out 3 terms: essentialia, naturalia, and incidentalia, right? Can you hear all 3 of those terms are Roman Dutch terms? It is Latin phrases: essentialia, naturalia, incidentalia, right? But can you see the core of the word is the English word essential? So when you look at your elements, there are certain elements that are essential elements to that specific contract, right? Secondly, there are certain natural terms and conditions that come into play with that specific contract. And lastly, incidentalia means incidental elements, that is, elements that have been created or put in place by the people themselves. Those are the 3 main aspects then. And I've set out for you with that essential elements of a contract. Incidentalia, what does that mean? Naturalia and essentialia, right? Now, I've said that might still be a little bit confusing. Let's look at each one of them separately. The essential characteristics of a contract, right, refers to what type of contract it is. So if you look at a contract, you can easily see whether this is a contract of sale, whether this is a contract of lease, whether this is a contract of what? A credit agreement, right? So the essentialia, right, looks at the different types of contract and then say that that contract should have certain clauses. For example, a contract of sale, do I have that? A contract of sale will only be a contract of sale if it shows that there are certain goods being sold from the seller to the buyer, and that the buyer is paying an amount to the seller. So a description of the goods, the price of the goods being sold. That is the essentialia of the contract. Okay. So essentialia refers to the type of contract, and how do we know it's that type of contract? So what are the characteristics of that type of contract? The naturalia are terms in that type of contract that do not need to be set out. So, for example, you will see in a contract of sale, the parties agree about the thing being sold and the price. But the naturalia says, in order for the thing to be sold, surely the seller must hand over the thing to the buyer, right? So we say the seller must hand over the goods, the buyer must pay the price. Ownership will transfer from the seller to the buyer, etc. So naturalia, we say, is reached, once an agreement is reached, there are certain associated provisions in law which automatically comes into operation. So they said naturally these terms and conditions come into play. The parties do not need to parties do not need to agree expressly on these terms. It is automatic through the law. And then lastly, when you say incidentalia, as I said, incidentalia is self-imposed terms and conditions. For example, with a contract of sale, you have agreed to the price. The incidentalia would be where the buyer and seller agrees that the buyer will pay this purchase price over 3 equal installments or 4 equal installments. That would be an incidentalia, right? So how the purchase price will be paid, the payment method, right? So how would that be paid, etc. That would be your incidentalia. So have a look at those 3 aspects, right? Essentialia, naturalia, incidentalia, so that you at least have some idea as to what it means. Essential characteristics specific to that type of contract, or natural terms and conditions flowing from that contract, or incidental, so things, terms and conditions that have been included specifically by the parties into that contract. Right? Okay, I've set out again the essential requirements for validity, and then I set out this issue of void and voidable contracts. So a void contract, a contract is deemed to be invalid from the beginning of its existence. Right? So that is what a void, if the contract is void, it was invalid, there's no rights and duties. If a contract is voidable, that means the parties entered into the agreement, the contract is valid, but one of the parties, we say, set aside on the application by one of the parties. So one of the parties go to court and ask the court to set aside that contract, right? So I said there, that table, I've included that for you on the, that last thing. Okay. So, good people, when it comes to definitions, formalities, and essentialia or essential elements of a contract, I think those slides is very short. All in all, I think it's about 30 pages, the slides. You know, it's hopefully easy to understand. I hope you are able to read through the slides and go, okay, I understand, you know, vaguely what is happening and what are the requirements. So it does become a little bit more tricky as we go along. Next week, we will definitely start looking at consensus, so agreement, meeting of minds, offer, acceptance, and that is a little bit tricky. You have to keep your wits about you there. But I hope that today was okay, that you are able to follow, and at least that it inspires you to go and read the textbook, those pages in the textbook, etc. Right. Any questions? Any questions from your side? I am going to also, I'm stopping this recording, but I